Welcome back to the deep dive. We are definitely on a mission here, working our way through the MPEP section by section.
Yeah, it's quite the undertaking, but hopefully useful. We're breaking down this huge manual piece by piece.
Exactly. And today we're jumping into Chapter 1800. That's the one all about the Patent Cooperation Treaty, the PCT.
Right, the system that lets you file one international application to start the process in, well, a whole lot of countries at once.
And our specific focus today is Section 1828. The title is Priority Claim and Document.
A really core piece of the PCT puzzle.
For sure. So our mission, using the MPEP text itself, is to really unpack the key rules, the procedures, and maybe some potential sticky points around claiming priority and handling that all-important priority document when you file a PCT application.
Okay, let's unpack this, starting with the absolute fundamental requirement in 1828.
Lay it on us.
If you file a PCT application,
Right.
right, and you want to claim priority maybe back to a U.S. provisional or a foreign filing, whatever it is.
Uh-huh. You want that earlier date acknowledged.
Precisely. The MPP is, well, crystal clear. You must provide specific details about that earlier filing.
And this isn't something you can just add later whenever you remember.
No, that's a critical point. The MPP says this info has to be there at the time you submit the international application. It's foundational.
Right at the start.
Yep. If you miss putting it in the request initially, well, you're already looking at needing to follow correction procedures, assuming you even can.
Okay, so what specific details do they need right up front?
The MPP, and it points to PCT Rule 4.11, says you need 3 key things. The country or office where the earlier application was filed,
Okay,
the date it was filed,
makes sense.
and its application number. Those 3 bits of data. That's how the system officially links your new PCT app back to the old one. Super important for prior art down the road.
You mentioned it could be an earlier foreign application. Does it absolutely have to be from a country that's part of the Paris Convention, since that usually governs priority?
Ugh, that's an interesting wrinkle the MPEP highlights. You can actually claim priority from an earlier filing in a country that's a member of the World Trade Organization, the WTO,
Mm.
even if that country isn't part of the Paris Convention.
Oh, interesting. That opens things up a bit.
Mm.
Is there a catch, though?
There is, and it's a big one, the MPEP flags. While the PCT system itself lets you make that claim to a WTO-only country,
Right.
whether that claim actually gets recognized, has legal effect when you enter the national stage in individual countries, well, that may vary by state. Each country's own patent law decides if they'll honor priority from a non-Paris WTO member filing.
Yeah.
So you can state the claim in the PCT, but it might not stick everywhere.
Good to know. Okay, so ideally, you have the country, date, number ready to go when you file the PCT. But life happens, mistakes are made. Or maybe you realize later, oh, I should have claimed priority to that application too. Can you fix it? Can you add a claim?
Yes, thankfully, there's a way. The MPP details the procedures, referencing PCT Rule 26, Quarter Cont 1, and the admin instructions. You can correct or add a priority claim if you missed it, or maybe typoed the number or something.
Okay, that's good. But I'm guessing there are strict deadlines. It's patent law, after all.
You guessed it. Absolutely. It's not like you have forever. The window is very specific. You generally have to make that correction or addition within 16 months from the priority date of the application you're claiming.
16 months from the priority date. Okay.
But there's another deadline that bites sooner sometimes. It also has to be done within 4 months from the international filing date of your PCT application.
Okay, so 2 potential deadlines.
Exactly. And you're stuck with whichever one expires earlier.
Right, so you need to check both dates, 16 from priority, 4 from PCT filing, and see which one comes first. Requires some careful calendaring.
Totally. Miss that earlier deadline, and generally you've lost your chance to fix or add the claim under these rules.
Okay, so step 1, declare the claim, hopefully correctly at filing, or fix it quickly within those deadlines. What's next? What about proving the earlier filing exists?
Right. The next big step is providing the evidence. That's the certified copy of the earlier application, often just called the priority document. It's the official proof of what you filed and when.
Where does that need to go? Do you just attach it to the PCT application?
You have options. According to the MPEP, you can submit it right along with the international application itself,
Okay.
or you can send it in separately later. And you can send it either to the International Bureau, the IB in Geneva, or to the receiving office, the RO, where you filed your PCT app, like the USPTO if you filed there.
And the deadline for this document, is it that same tricky 16 or 4 months rule?
Nope. Thankfully, a little simpler for the document itself. The deadline is just 16 months from the priority date. That's PCT Rule 17.1a.
Okay, just the 16 months from priority. That's clear. Now, lots of folks listening probably filed their first application, maybe a provisional, right here at the USPTO. If that's your priority document, is there an easy way?
Yes, definitely. If your earlier application is a U.S. one, and you're using the USPTO as your receiving office, what they call MARIS,
Uh-huh.
the MPP points out a really handy service. The ROS can actually prepare that certified copy for you and send it electronically straight to the IB.
Oh, wow. Does that cost an arm and a leg?
Well, here's the great part the source mentions. Often, it's free, no extra fee, as long as your international application was filed on or after August 31st, 2007.
Nice.
Yeah, you just check a box on the PCT request form, like the PCTR 101 form. You basically just ask the ROS to grab it and send it for you. It's a huge time saver.
That sounds way better than getting it yourself and mailing it. So once the IB has it, what do they do with it?
That's where the PCT system really shines. The IB then makes that certified copy available to all the patent offices in the countries you designated in your PCT application.
Ah, so you don't have to send copies to like 10 different national offices later.
Exactly. The IB handles distributing it, usually electronically these days, through systems like the WIPO Digital Access Service or DES. It really cuts down on your burden when you enter the national stage later.
That is a major plus.
Hmm.
But the MPP usually mentioned potential problems too. Does it warn about anything that could mess up this smooth process?
It does. While it usually works well, a couple of things can cause delays or even prevent transmission. One big one is national security review.
Yeah.
If your invention falls into certain sensitive tech areas, it might get flagged, and that review can hold things up or even lead to a secrecy order preventing transmission.
Okay. Anything else?
Another potential issue mentioned relates to inventorship. If the inventors listed on the priority application aren't the same as on the PCT application, well, while the PCT itself might allow the priority claim, the lack of common inventorship can cause issues, especially when entering the U.S. national stage. There are specific U.S. rules like 35 U.S.C. 120 and 37 CFR 1.55 about benefit claims that often require at least one common inventor. So mismatched inventors can complicate things.
Right. So getting the certified copy sorted, ideally through the RUS, is key. Now, we've been assuming you filed the PCT within the normal 12 months from your priority date. What if you just miss it? You file late. Is it game over for priority?
That's a scary situation for sure. And it leads us right into Section 1828.01, which talks about restoring the right of priority. There is a potential way back, but the window is tight.
A lifeline, maybe. How does that work?
Okay, so if you filed your PCT application after that 12-month priority period was up,
Yeah.
but you filed it within 2 months after the 12-month deadline expired, then you might be able to request restoration. It's a strict 2-month grace period, basically laid out in PCT Rule 26, quarter point 2.
Okay, 2 extra months to file the PCT and request restoration. What do you actually have to do to get it restored? It can't be automatic.
Definitely not automatic. You have to file a specific request, and the MPE lists the requirements. First, you need to convince the office that the delay in filing the PCT app was unintentional. That's the key standard, at least at the USPTO.
Unintentional. Okay. What else?
Second, the request itself has to be filed within that 2-month window. Third, pay a petition fee. Fourth, make sure you've actually included the priority claim itself, maybe via a notice adding it, if it wasn't in the late filed PCT request. And fifth, you need to provide a statement explaining why you were late, what caused the delay.
That word unintentional seems important. Does it mean the same thing everywhere? Is it a high bar or a low bar?
This is a really crucial point the MPP makes, a potential gotcha if you're not careful. The MPP says the USPTO, when it's acting as the receiving office, applies the unintentional standard.
Okay, and what does that generally mean?
It's usually seen as a less strict standard. Basically, the delay wasn't like a deliberate choice to abandon the priority claim. Think clerical errors, system glitches, genuine mistakes that weren't intended to cause the deadline to be missed.
Right, so that's the USPTO. What about other patent offices around the world?
And here's the critical difference. The MPP warns that other offices, either as receiving offices or later when you enter their national stage, might apply a stricter standard called due care.
Due care. What's that?
Due care generally means you have to show you took all reasonable steps you could have been expected to take to meet the deadline, but you still missed it due to some exceptional circumstance beyond your control. That's often much harder to prove than just unintentional.
Wow. So, depending on where you file the PCT or where you eventually want protection, your chances of getting priority restored could be totally different.
Exactly. And this difference leads to a strategic point the MPP mentions. If you're worried you might need restoration and you know some of your target countries use that tough due care standard, it might actually be better to file your PCT application directly with the International Bureau, the IB, instead of the RS.
Why is that?
Because the IB, under the rules, can actually apply either standard unintentional or due care, depending on what the designated offices require. Filing with ROWS locks you into the unintentional standard review by the RO, but the national offices might still hit you with due care later. Filing with the IB gives more flexibility up front to potentially meet either standard as needed for different countries. It's a bit complex strategically.
That definitely adds a layer of complexity if you miss the deadline. Are there any other big warnings about relying on this restoration process?
Yes, two important ones, the MPP flags from the PCT rules. First, national security provisions always trump this. If there's a secrecy order, restoration might be irrelevant or impossible.
Yep.
Second, and this is really critical, even if you do get your priority restored successfully during the international phase, some national offices, when you go to enter the national stage later, might still refuse to recognize that restored priority right. This can happen if restoration is just flat out incompatible with their national laws.
Ouch. So you could win the restoration battle internationally, but still lose the priority war in certain countries.
Pretty much. You might end up with an effective filing date much later than you thought in those specific countries, which could let in damaging prior art. It really underscores how vital it is to hit that 12-month deadline in the first place.
Absolutely. Restoration is a fallback, but maybe not a foolproof one.
Right. A safety net with potential holes.
Okay, let's shift gears a little. Another common thing, especially here in the U.S., is filing continuations or continuations in part, CIPs, that claim benefit back to an earlier parent application. How does that work in a PCT application?
Good question. That's covered in section 1828.02. This part explains how you indicate on the PCT request form that your new international application is a continuation or CIP of an earlier one. This is all about getting the benefit of the parent's filing date for shared subject matter under national laws, like our 35 U.S.C. 120 or 365C.
So how do you make that indication correctly on the PCT form?
The MPP says you need to clearly identify the parent application on the request form. PCTR 101 is the usual example. You need its application number.
Okay.
You also have to explicitly state the relationship. Is it a continuation or a continuation in part? And if the parent was itself a PCT application, you also need to provide its international filing date.
And what's the advantage of putting this info right there on the PCT request form?
The big benefit is streamlining things, particularly for entering the U.S. national stage. If you make that reference correctly on the PCT request, parent number, relationship date if needed, you generally satisfy the U.S. requirement under 37 CFR 1.78 for claiming benefit.
Ah, so you don't have to file a separate paper in the U.S. later just to claim benefit.
Usually, no. Doing it correctly up front in the PCT request can save you that step and potential hassles later. It helps make sure you lock in that earlier filing date benefit under U.S. law smoothly.
Makes sense. Avoids procedural headaches down the line.
Exactly.
Wow, okay. This has been a really detailed tour through Section 1828 and its subsections. We've hit on the initial claim details, the certified documents, fixing mistakes, the whole restoration process, and now continuation status. Let's pull back. Why should you, the listener, really care about getting these PCT priority procedures right?
Well, getting this stuff right is fundamental. It's all about locking in your priority date. And that date is incredibly valuable. It basically determines what counts as prior art against your invention.
Right. Anything published after your priority date but before your PCT filing date might not count against you if you've properly claimed priority.
Precisely. Think publications, other patents. Sales, that priority date acts like a shield. It can literally be the difference between getting a patent granted or rejected, or even determine if a granted patent holds up later if challenged. Getting the earliest valid date is key.
So this isn't just checking boxes. it directly impacts the strength and validity of your potential patent rights.
Absolutely. And getting it right the first time avoids needing those complex deadline-driven correction procedures. Or worse, trying for restoration, which as we saw can be uncertain and isn't even accepted everywhere. Messing this up can mean losing that crucial priority date permanently.
And knowing the continuation CIP rules helps smooth out entry into places like the U.S.
Yeah, it just makes the whole process less prone to procedural errors when you transition from the international phase to the national phase.
It really sounds like mastering these 1828 procedures is essential for anyone using the PCT effectively.
It really is. These rules are the mechanism for ensuring your international filing properly connects back to your earlier work, preserving your rights globally.
Okay, that wraps up our deep dive into MPP Section 1828. We've looked at making the initial priority claim, getting the certified copy submitted, the deadlines for fixing errors, the tricky path of restoring priority, including that key difference between unintentional and due care standards, and finally indicating continuation or CIP status in the PC2 request.
So maybe a final thought for you to ponder. Considering all the deadlines, the specific requirements, the potential roadblocks like security reviews or differing national laws on restoration, how much could meticulous upfront planning, really thinking through your priority claims and document strategy before you even file the PCT application, actually smooth out the whole process and prevent major headaches later on?
That advanced planning seems like it could save a lot of trouble.
It almost certainly does.
Before we go, a very special thank you to Mike Shepard, the creative director who organized this entire audio series.
And as always, the necessary disclaimer. This summary of the MPEP was generated using AI tools, including ChatGPT and Notebook LM, and may contain errors or omissions. It is provided for general educational and informational purposes only and is not legal advice or a substitute for formal instruction. For authoritative guidance, please consult the official MPEP, a qualified instructor, or a registered patent practitioner.
Thanks for joining us for the deep dive. We'll catch you next time as we continue exploring the MPP.